Is it working?
I think I can do the introduction.
Do you want to do the introduction, John? We're good? All right. Welcome to the whatever number it is of Questions for Lawyers. I'm still Jeff Adelman, the host, and he's still John Moran, my guest. This is going to be a terrific show if we can actually do it.
Jeff, I hate to cut you short, but that's all my time.
All right. This has been Questions for Lawyers. I have known John Moran since my days at Coral Springs High School. He is somebody who has so many interests, has always been one of the more interesting people that I know because he is so diverse. He was a state wrestling champion. He is a magician, and he is a world-class attorney at the Gunster Law Firm in West Palm Beach. And today we're going to be talking about probate litigation. John, thanks so much for being here with us today.
Thank you. Thank you.
Okay, and thank you for your patience as well.
When you do it live, man, I'm getting a real education on live Facebooking.
Yeah, you just never know what the problem is, but Facebook is apparently coming through where the other program did not. Can you tell everybody a little bit about what probate litigation is?
Well, probate is what happens when you die and what happens with your assets and how they get distributed. And probate litigation is when there are disputes about what happens when you die. And that could be a fight over a will. That could be fight over a piece of property, a house, or a car. So when you say probate litigation, what you're talking about is post-death disputes regarding people's property.
So fighting over money after death.
What else would you fight over?
Yeah, exactly. Well, if you could, tell the audience a little bit about what made you decide to become a lawyer.
Well, it wasn't really on my radar. There's no lawyers in the family, but when I was still in college at FSU, my mom picked up a book. I think it was at a bargain bin in Kmart, and it sat there for a couple years. But I came home from break one period of time, and I picked up this book. It was called Anarchy and Elegance: Confessions of a Journalist at Yale Law School. It's way out of print. You probably can't find it except in a used bookstore. And this was this guy who was a journalist who had gone to law school, and he was complaining about all these terrible things about law school. And yet everything that he was complaining about was something that I thought, that doesn't sound bad. So where he took a negative twist on things, I thought it sounded pretty cool. And that was really the catalyst that had me, filling out law school applications.
So his book had the opposite effect on you.
Yes, it did.
Well, maybe one day you should reach out to him and let him. I'm sure that he can be reached.
I don't know.
Maybe not. I don't know.
There could be a big run on Anarchy and Elegance on Amazon after this.
We'll find it for you afterwards, and maybe we can get it autographed. Now, tell us a little bit about your path getting to the Gunster Law Firm, a very well-respected law firm nationwide. Tell us how that came about.
Well, Gunster is just a Florida-only firm, okay. But I obviously after FSU went up to GW, was in D.C., thought at first when I went up there that I'd do international law. And I actually found out probably second semester, my first international law class, that there's really no such thing as international law. It means you have a client who's not in the United States. And so at that point, I started, exploring some other options and got interested in litigation. And for various reasons, my wife's family, my family, folks were back down here in Florida. The son, that's why we came back down to West Palm Beach. Well, and I've been at Gunster ever since. It's my first job out of law school. I've been there 18 years, my 19th year just underway.
Well, congratulations on that. And in addition to your work at Gunster, you're very involved with some of the Florida bar committees, or have been involved. Can you tell us a little bit about that?
Right. I know you're pretty involved with some stuff as well. I've been involved with the, we call it the reptile section. People go, what are you talking about, reptile? It's the RPPTL, which is Real Property, Probate, and Trust Law section. And that's the arm of the bar that deals with real property issues and probate and trust issues. And so I've been involved for several years, have been involved in a lot of committees, chaired the probate law committee of the reptile section for 5 years, and I'm currently in charge of all of the probate CLE, continuing legal education, for the section.
That's pretty impressive. How long have you been doing that?
Boy, I was trying to figure that out the other day. It's been probably going on 15 years being involved with the reptile section.
Are you involved in any of the rules committees as well?
I actually chaired the probate rules committee about 6 years ago. And that's the Florida Supreme Court sanctioned committee that deals with all of the probate rules that govern practice in probate matters in Florida.
Well, tell me, in your time working at Gunster, just being an attorney, what is your primary concentration?
Well, you said probate litigation.
When I say probate litigation, it means so many different things. I mean, you just mentioned that you do real estate, and that kind of goes hand in hand.
I don't actually do real estate. Gunster as a firm, we're about 200 lawyers, statewide, Florida focused, and we do everything soup to nuts for folks, the business work, corporate work. But for me, on a daily basis, I deal with what happens when somebody dies and when there are things that go sideways. I don't do very much planning at all. I don't actually draft wills or draft trusts, but where I do get involved on the front end is people trying to avoid disputes after they pass away. And my daily grind, so to speak, is dealing with administration of assets when people pass away, and also dealing with trial work and litigation like you do, right, but issues specifically dealing with wills and trusts and guardianships.
Now, your cases, where are they primarily? Are they in the circuit state court, federal court?
Mostly state circuit court, but all across Florida, primarily South Florida, but depending on the matter, we've got some things that I've worked on in Central Florida and on the West Coast. Most of these probate disputes, issues that come up when people die and fights over their assets, most of those cases are in state court.
And what I was alluding to before is, while you're not a real estate attorney, given the nature of probate litigation, you have to know quite a bit about real estate and those transactions and how to pull them apart.
There's definitely a niche aspect to what I do. There's it's a pretty tight community of lawyers who do this as their primary practice. But you're right. I mean, when somebody dies, you've got real property issues that come into play. Fights about, homestead. People in Florida, we have a unique property right with respect to homestead. That's your primary residence. And there's all kinds of very specific issues and fights that can arise from homestead property. And so you're right. It does touch on a lot of different aspects.
When you get right down to it, John, though, if people do things the right way, they can avoid very expensive litigation with you or anybody else who does probate litigation. How can people do that so that they don't end up spending their relatives' assets on probate litigation?
Well, there are certainly things you can do to try to prevent it. These fights over your assets after you pass away. There's no guarantees, though, because, people are people. And when money's involved, I know you see this, and anybody in our profession experiences this, people will fight no matter what the stakes are. But what I tell people in terms of trying to make sure you avoid fights primarily between your family members after they pass away is, number one, go to a reputable attorney. A lot of folks want to do their own will and get a form from Office Depot. And there's a brand new law that we can talk about if you'd like, that's coming on board pretty soon with respect to electronic wills. But Florida has some very specific requirements in order to make a will valid. And it's not just filling it out and making sure it says where your assets go, but there are very specific, strict requirements about how you're supposed to sign that will. In Florida, you need to actually sign the will in the actual physical presence of two witnesses. And if you want to simplify the process for the folks after death, also in the presence of a notary. If you don't do that, no matter what your piece of paper says, it's not valid. So the first tip is make sure you go to somebody who knows what they're talking about. The other thing, and this is something that I've seen, having dealt with the fallout from fights post-death is that if you're going to be making changes to your will or laying out a disposition of your assets, that really isn't the natural way, split between two siblings or split equally amongst family members. Communication's important. It's a good idea to have those conversations ahead of time and I'm talking about with your witnesses, with your family members, so that their expectations can be in line. But also, if you don't want to talk about that, in a lot of circumstances, you're just kicking the can down the road for when you're gone. And I've seen a lot of families torn apart by surprising, dispositions or surprising information in a will that they go, wait a second, mom or dad didn't tell me that's how it was going to be. Keeping documents up to date is critical. People get divorced, people have new kids. There are some wills there's some laws that kick in to protect folks from those things. But the best thing to do is to make sure your documents are current, especially if you have major changes. One of the biggest, this is a red flag. If you go into a lawyer's office in Florida, now every state's different, but in Florida, and your lawyer says to you, hey, don't worry about a challenge post-death. We're going to put a no contest clause, or an interim clause is what it's called. And it's a provision in a will that, if you didn't do this on a daily basis, you read it and say, anybody who challenges this will is cut out. That is not enforceable in the state of Florida. It's invalid. Doesn't matter what your will says about that. And so, that's not going to give people the protection, in Florida at least, that they might otherwise think.
Other states have clauses like that you can put in there?
They do. It's very state dependent. It's another reason why when I talk about getting to a lawyer from a planning perspective, it's really important to go to somebody who knows the law of the state that you reside in. Florida has some very specific issues or very specific laws dealing with homestead, dealing with things like this no contest clause, that are important to make sure you have somebody who knows what you're talking about. I see a lot of transplant folks who are from the North or the Midwest who do wills up there that, they don't ever really get around to updating them when they go to Florida and they move to Florida. And that really can cause some issues when they pass away if they haven't kept them up to date.
What kind of problems can arise if you don't update your will if you're a resident of Florida now and you had done it in another state?
Well, you could have issues with respect to your homesteads not properly dealt with, all kinds of things. I mean, it's a whole laundry list. The point, though, without getting too technical, is that keep them up to date, especially when you have a major life change, a divorce, a child. It's not just, to keep them fresh. It's to make sure you keep them valid.
Right. And there are some rules in terms of residency for doing a will in Florida. You have to live here for a certain amount of time.
Yeah, that's more tied to treatment of income tax. Folks living in New York, of course, one of the best reasons to move to Florida is we don't have a state income tax.
Absolutely.
And so it's not so much tied to your domicile. The question of domicile under the law is really what your intention is. If you intend to move to Florida, then that can change your domicile. It's really a question, and the reason people make that change is because of income tax issues. They don't want to get audited by, the state of New York or some other state that has income tax and not make sure they've done the things they need to do to properly, lock down residency and domicile in Florida.
You had mentioned that there's some changes coming down the pipe beginning January 2020 and then in July 2020. Can you tell us a little bit about some electronic changes that are happening in Florida?
Right. We're making a big deal about how important it is to have somebody who knows what they're doing execute your will and the draconian old requirements. The current law for executing a will dates all the way back to 1670 with the English Statute of Wills. But effective January 1st, 2020, and then with respect to electronic wills on July 1st, 2020, there's major changes coming in the state of Florida with respect to online execution of documents. January 1st, folks are going to be able, just like we're doing here, go on using a webcam and have a notary remotely notarize a document. There's all kinds of technical issues that are in the statute. It's the new statute. It's got a lot of nuts and bolts in it. But that's a big change in Florida law. But for me and for what I do, electronic wills are now going to be valid as of July 1st, 2020.
It just sounds crazy to hear that.
And an electronic will is a will that really never exists on paper. And the concept is that if you go through the appropriate hoops, you jump through the appropriate hoops, you're going to be able, if you want, to go online, create an electronic document, and then have an execution ceremony where, again, I made this big deal about how important it is to have these documents properly signed. The concept here is that you'll be able to do it through your webcam. And there's all kinds of additional requirements where you need to, if there's an elderly or somebody who's susceptible to elder abuse, there's some specific questions that need to be asked. There's issues with respect to the audio-video technology. Just like this video, they need the custodian of this electronic will has to maintain the video showing the execution. So it's a very, very significant change in Florida law. Be interesting to see how it turns out. A lot of lawyers who do what I do are skeptical about how this is going to be, and a lot of folks think that it might lead to more disputes. I don't know. We'll find out in a couple of years. I think there's going to be some test cases pretty soon. I think. I'm
just looking at the list of people who are watching, and there's several on there who are estate planning lawyers, and you being the CLE chair. Does the bar plan on having some CLEs in the upcoming future regarding this huge change?
Absolutely. In fact, December 17th, I believe, we have a webinar focused exclusively on doing proper notarization in the state of Florida. If you go to the Florida Bar website or the RPPTL website, you'll see it there. You can register. It's essentially correct notarization in the state of Florida. We're also putting together some pretty extensive seminars that are going to be rolled out, I believe, in early 2020 about electronic wills. Also, for the lawyers paying attention, if you didn't see it already, there's a great article about all of these changes in the most recent Florida Bar Journal, written by Jenna Rubin and Sarah Butters on this issue.
Well, that's very good to know. Hey, Michelle. Michelle is one of those estate planners that I was telling you about.
Excellent.
Now, with regards to, and it's interesting with regards to the notary, because with what I do, a lot of times I get releases from personal injury, and I got to get the client to notarize it. Like, what do you mean? I got to come to the office and notarize it? So it's actually going to change what we do also. I'm going to have to get with the program.
Anybody that is executing documents that require notarization is going to have a new option. And it's going to have, some specific new requirements, and folks who are going to be remote online notaries are going to have to take a course in order to make their, notarization valid. But yeah, a lot of folks, especially in the real property side, are pretty excited about this. They think it's going to help simplify the execution of documents.
I think overall it probably will, but it's just whenever they bring a change to us lawyers, we're like, oh no.
Oh. Well,
we think about all the bad things that can happen.
That's what happened in Tallahassee with the Florida Bar Reptile section. We see a lot of potential downside to this with respect to fraud and concern about abuse of the elderly. Florida is ground zero for those types of elder abuse crimes. But when we were arguing to the legislature about all the potential downsides, they specifically, called us lawyers out as being very old and antiquated, and it's time to get into the 21st century. They said, "What did you take your cart and buggy up to Tallahassee to give these comments?" They literally said that during committees.
Yeah, I think they're probably right, but that's just the knee-jerk reaction. I think, for people who've been doing this, longer than a decade.
Listen, if you do what I do, which is deal with disputes, could be interesting. I don't know if it's going to be good or bad. It could bring a lot of folks head to head with some new fights for new grounds that we really haven't seen before.
For sure. Well, John, let me ask you this. Somebody is in a probate dispute with their relatives. They're fighting over property, they're fighting over assets, and they need to hire a probate litigator. What can a new client do for you to help you the most in the beginning stages of the litigation?
That's a good question. I think that one of the most important things that they need to do is be able to very quickly put together a family tree, a list of the parties involved and what the natural relationships are. That somebody who does what I do and deals with post-death disputes, the first thing they're going to ask is, who are the family members? And are there kids? Are there minors involved? All of that stuff's very important to figure out, who the proper interested parties are. The second thing they need to do is to gather whatever documentation they have, copies of wills, any legal documentation that might relate to deeds, wills, trust, that type of thing. And maybe most importantly, to the extent they know, would be to be able to give their potential lawyer a little bit of an idea of the assets. Because the way that, a skilled lawyer, in my opinion, will approach these disputes is in large part dictated by what types of assets you have. If it's just marketable securities or cash, there's a certain way to approach a case like that. If you're talking about selling and splitting up a homestead, the family house, or, I've seen disputes and been involved in them over extremely expensive classic cars. You're talking about a different animal. So family information, documentation, and whatever information you can put together regarding the assets is critical for somebody evaluating one of these claims on the front end.
Kind of tying in with what you were saying before, communication.
Critical.
Because if you communicate, you can deal with a lot of the issues that may come up. If you get blindsided, who knows what's going to happen? You're not prepared.
I mean, look, if you're doing a will, or your mom or dad or uncle is doing a will, and they're not going to be passing things out equally, the best defense against a post-death fight is having an open line of communication so that your beneficiaries have some idea about what to expect when you're gone. Otherwise, some of them get hit with a 2x4. Old Hacksaw Jim Dugan style.
Oh, jeez. Nobody would want that.
I hate to crowbar that in for such a wrestling fan.
Oh, it's never happened on the show before.
Well, I don't know. but my point to you is that that's the best defense. You've got witnesses who can talk about what the person's intent was. When you get into one of these disputes, under Florida law, we say that the pole star of how these things turn out is tied to what the testator or the person doing the will, what their intentions were. And that's going to be the guiding principle for how a lot of these cases are resolved by judges. If you can express what your intentions are openly, that can help. Now, that kind of cuts against the conventional wisdom, which is, this is my private business, and I don't really want my kids to know about it. But if, you're sensing that there could be animosity post-death, in my view, it's almost always better to kind of get that out of the way before you're gone. Because if you think your kids or beneficiaries are going to fight while you're here, there's a guarantee they're going to fight when you're gone.
It's interesting. We were talking before we went on the air about, in the movies, the video wills and all that, which you told me that doesn't really happen. Well, but maybe with some of this, with the video notary and all that, maybe some of that will come into play a little bit.
Jeff was asking me, is it like in the movies where there, somebody videotapes their last wishes and then there's a reading of the will? Well, Florida law calls that an uncooperative will, an oral or video presentation. Not valid, by the way. But, it's great for the movies.
It's terrific for the movies.
Terrible in real life. But you're right. With all this online notarization and electronic wills, one of the key components of having a will that flows through probate that's electronic is that there's going to be an audio-visual record that gets attached or kept anyway with your electronic will. And in certain circumstances, that's what you're going to need to prove up the will or to make sure that it goes through the probate process. Sure. So I don't know. I dealing with disputes be really interesting because there's a lot of folks who say, hey, that's a great idea. Let's videotape that. I can't remember seeing a will execution where somebody looked good. It's amateur hour photography. They all look bad. Even when somebody is sharp as a tack, they look bad. So be interesting.
Well, hopefully we look good on here. So because you said that about video, but I have some doubts about the shine today, but whatever.
Yeah, you look good. I see he powdered himself down before we started. So
yeah, well, usually that's safe practice. Today it's not working with all the blips.
Look, we have another Coral Springs alumni, Steve Bissonette joined. Hey,
yes,
Steve, how's it going?
We had a few on there actually. Let me see if they're ready. Tino Sablotny.
Yeah,
and I'm sure there will be more later. Well, let me ask you this. I asked you if somebody's looking to hire a probate litigator such as yourself, what should they do to help? Can you give me some examples of some really bad things people have done that have made your job harder? It's like if you're watching right now and you need a probate litigator, don't do this.
There's a couple of ways that people get into disputes post-death. When somebody's challenging a will, there's kind of like 4 or 5 angles. One of them is, as we've talked about at length here, mistakes with the execution of the document. Sure. That's number one. Number 2 would be a challenge to the person's mental capacity. And in Florida, we call that testamentary capacity. It's interesting because the standard in Florida for testamentary capacity, in other words, the mental ability or acuity to make a will or make a testamentary disposition, is very low. And when you think about it from a constitutional and property perspective, that's where you want it. You only really want to you don't need to know much or remember much to be able to say where you want your property to go. But one of the mistakes that people make is that, as their family member or whoever it is starts declining in later years, we're seeing more and more fights over their capacity and changes they may have made kind of pre-death. And if you jump the gun on that, it can be terrible. What happens is somebody says, I believe that my brother has gotten in my parents' ear and they're controlling him and they've changed the will and I need to do something now. And a lot of folks will say, well, your option is to file an action for guardianship, declare that person incapacitated, and go get a guardian appointed. One of the documents you can do for estate planning is kind of state ahead of time who you want your guardian to be. But aside from that, if somebody's wrong about that, capacity, if you haven't really, you think dad slipped, but they really haven't when it comes to the actual legal test, and you file an action, that's exhibit 1 in your will contest. That's the reason that people say he got cut out. So-and-so Susie said, I didn't have my faculties anymore. She filed an action saying I was incapacitated. That's why I cut her out. And that's what you'll hear. So,
right.
It's a very delicate situation, especially dealing with elderly folks in Florida. But I think a lot of people are at risk of jumping the gun on this. Sometimes as dangerous as it is that the assets, you're not sure where they'll be or if they'll be left. If you jump the gun, you may shoot yourself in the foot.
We have a question here from Michelle Reichler, who's an estate planner herself. How would you like to see attorneys document someone's testamentary capacity prior to drafting a will?
It depends. It depends on your client. It depends on the circumstances. In one of the most interesting ways that challenges play out is if there are multiple wills done at different times that make incremental changes. And so I understand Michelle's asking about how would you document it, but one of the things that you can do is have multiple wills that kind of make the changes up to the final change. Because when somebody's challenging a will, they got to challenge all of those wills to get back to the one that they're either in or to say that there's no will at all. I think that it's, in my experience, Michelle, it's dangerous to have a videotape. It's also kind of a mixed bag as to whether or not you send somebody out for a medical or some type of other mental acuity test, like a mini mental exam. I would do that or consider doing that if I felt very confident in my client's capacity. If I wasn't sure, and you're anticipating a change, maybe you don't do it. Or maybe you're just trying to find out for yourself. You're not really necessarily anticipating a dispute, and you just want to know, what the doctor says. That's more of the circumstance where I see somebody, going to the doctor. The lawyer isn't sure, and they don't want to substitute their judgment for, a practitioner who specializes in that type of thing.
Makes sense.
But it's also pretty important to, keep good notes of the meeting. A lot of disputes, again, we're talking about capacity, but a lot of disputes arise around, execution, and make some notes about your observations of the witness. Are they oriented to person, place and time? Who was there? Have your paralegals or other witnesses record some contemporaneous notes. Those things are always very important in trying to hold up a will that's being challenged on the basis of capacity.
We actually have another question from Paula Bloom. How often should I review my will?
That's a tough question to answer. I think, as we mentioned earlier, the law is frequently changing. There's no set answer to that. Certainly, I think a good time to review your will or your trust is when you've made a big life change, you've moved, you've had kids, you've gotten married, there's been a divorce. Those types of things are triggering events. The law is frequently changing. If you have less than 11.5 million or so, the tax laws don't really impact you very much right now. But when you are in the upper echelon of having significant dollars in tax planning, that's when it becomes more important to kind of update that and see your estate planning lawyer at least on an annual basis.
Now is the big question. Who is FSU going to hire to replace Willie Taggart? Because I'm concerned.
Don't be concerned. Don't be concerned. We were talking before the interview here about, Taggart's tenure. I feel bad for the guy, but I know some people will say he's going to do fine, and he will monetarily. I don't know. I think all the signs are pointing to one of the Stoops brothers, Bobby Stoops or Mark Stoops. I'd be happy with either one.
And either one would be a good hire.
As long as we put up a good fight against the Gators, that's all that matters to me.
Every year, isn't that the case?
Oh, I need it big this year.
Yeah. Well, I might not watch this year.
Well, I told you I have a bet with one of my colleagues, Bill Hennessy, where we've really upped it. We bet on the tie. He's a Gator fan. I'm an FSU
But
fan.
everybody does the tie. Oh, objection, relevance. We're getting into we're getting controversial.
Overruled, Michelle. But this year we really ramped it up, and I regret it, but I can't back down now. We bet that the loser has to go to the DMV and actually get the other team's license plates. So if you see a truck driving around with a Gator license plate, there's a good chance it's
with a frowny face.
Good chance.
Oh man, that I've heard of people having the name change, and I almost feel like that's worse because people see it all the time now.
I can't talk.
I don't know why you did that.
I did what I had to do.
Yeah.
It was before the season.
You're a good man. To continue with that. Well, John, this has been an absolute pleasure to have you on. I've wanted to do this for a long time, and I think you've provided a lot of really valuable information to lay people and to lawyers about probate litigation and really how to stay away from it as best you can. And if you're in it, how to make it the least painful as possible.
There was an excellent judge who used to sit on the 15th Judicial Circuit, Mary Lupo. She was in the probate division for a long time, and she said that probate disputes were like family law without the sex. And she's right.
Mm-hmm.
It's very emotional. And if there's things that you can do, especially as the person creating the will or trust, to, allow your family to remain intact after you're gone, those are good things to do. It's a shame seeing families torn apart over, assets post-death.
Yeah, it's some heavy emotions, about the heaviest you could get right there. Well, thank you to all of you for your questions and for watching and listening. The show will be replayed again on Facebook, YouTube, and we will be uploading it to your favorite podcast platform, Apple, Google, Spotify, iHeartRadio, the whole shebang. But we appreciate you listening, and my name is Jeff Adelman. John, if you could, can you please tell the viewers, listeners, how they can get in touch with you?
Sure. You can check out the Gunster website. I'm on there, or you can email me at jmoran, JMORAN, at gunster.com, or you can contact me at my office. That number is 561-650-0515.
Whoops. Try to do it quick. All right. Well, again, thanks so much for being with us. We'll see you next time. Be well.